Um, Good afternoon, everybody, or good morning to some of you. I know that some of you are tuning in to our webinar today from Europe, and very welcome, and certainly to our friends in Asia, in the LAWASIA region. For most of you, it'll be afternoon, so good afternoon to you. My name is Tim Castle. I'm a barrister and senior counsel at the bar in Sydney, Australia. I'm chair of the LAWASIA and UNCITRAL committee, and I've had quite a long experience with things to do with UNCITRAL through personally attending UNCITRAL meetings, but also more recently in relation to LAWASIA. We've had an UNCITRAL committee going for the last couple of years, and some of you may know of some of the work we've done. At the CM REAP conference in 2018, we presented a panel, a presentation live in relation to cross-border insolvency. And then in 2019 at our Hong Kong conference, we presented a panel presentation in relation to e-commerce. Of course, because of the pandemic and COVID, we're now providing our seminar content through webinars, and I should express our gratitude very much to the LAWASIA Secretariat, to Magda, Imri and Shanaventra for making this all happen. We've had an overwhelming response to this seminar, so thank you very much for joining us. I think we had over 300 people register from 52 jurisdictions, which is fantastic. For those of you who are new to LAWASIA, don't know anything about it, LAWASIA was formed in 1966, so 55 years ago, as a way of bringing together different groups of lawyers in the Asia and Pacific region. And throughout that period, we've enjoyed a very close and a very good relationship with the United Nations, and in particularly UNCITRAL in general. So we're delighted this afternoon to be able to present to you in this first webinar an overview of UNCITRAL as we are today in 2021, talk about some legal developments. I think before introducing the first speaker, I should just mention that UNCITRAL manages to achieve a huge amount in the area of private international law. And it does so with a very small, highly qualified and specialist staff of only 14 permanent legal officers, of whom we have a number here today who'll be providing presentation. And in addition, there's one regional centre which we have in the Asia Pacific region at Incheon in the Republic of Korea. So we'll be covering both the work that UNCITRAL is doing generally, but also the work that's being done in the regional centre. I'd like to thank those of you who have provided questions in advance, and hopefully we'll have time to come to some of them, probably not all of them today, but that will take place a little bit later in the seminar. There is a possibility of asking questions as you go along. Please use that. Please identify the person to whom you're asking the question. We'll do our very best to simulate what we used to do in the live presentations, which is to hear the presentations first and then deal with questions afterwards. If your question isn't answered directly, then we may be able to provide you with a response afterwards, but the speakers today will be doing their very best to address at least a couple of questions which seem to have a general application. So without further ado, I'd like to now introduce the first of our panel presenters, Carolyn Nicholas. Carolyn is the head of technical assistance at UNCITRAL. She's a senior legal officer, and she has previously served in a number of areas of UNCITRAL's work, particularly Working Groups 1 and Working Group 3, highly qualified from a practice in law and also with a range of economic degrees and other degrees which equip her very well for the role that she currently has. So with that introduction in mind, let me hand over to Carolyn.
Thank you very much, Tim, and I'd like to thank LAWASIA for this opportunity to connect with a lot of people who are interested in UNCITRAL's work that actually we probably normally wouldn't have the opportunity to do. So it's really welcome. Now, giving me any in charge of anything technical is always a bit of a hit and miss affair. So I'm going to try and share my screen. And let's see if that works. And if one of our colleagues from LAWASIA just confirm you can see the screen properly. Just nodding. That's super. Thank you very much.
Thank you.
So thank you very much. Now, what I'm going to do for you today is to explain a little bit about UNCITRAL and what it does and what it doesn't do. Many of you may have come across UNCITRAL really through references in contracts to the UNCITRAL arbitration rules. That may be it's a very common point of entry to UNCITRAL, but we're actually a much broader institution than that. So I'm going to focus at a big picture level on what it is that we do and why we do it. So to start with, Tim kindly mentioned the concept of international trade law. It's in our name, the United Nations Commission on International Trade Law. And one of the common questions that often is given to me is, well, is that the same as the WTO? Is that what you do? And the answer to that is no. We're actually quite different from the WTO. And so one of the things I want to emphasize here is that we tend to call it international private law, not private international law, as many as you know, that really refers to choice of law issues, but we deal with international private law. So what I want you to think about is not sitting in the WTO arguing about tariffs or dumping or state-to-state relationships and how states agree to treat each other's businesses and so on. What I want you to think about is yourselves and your clients sitting in South Asia or Southeast Asia or Australia or East Asia or wherever, wanting to sell overseas. Private companies wanting to sell overseas. And so that's the area that we address. And what we're trying to do is to enable these international commercial transactions. So we're trying to allow the hypothetical, I don't know, Kenyan flower seller to sell his roses around the world. We also recognize that if you're going to encourage people to sell overseas, that they have to have confidence in the legal system where they're selling. They need to know they'll be treated fairly. And the same points apply to international investment, because one way you may choose to sell overseas or to trade overseas is by setting up a related company in a different country or by investing in that country. So that the point covers too, that we include sort of the domestic international environment and international investment from that perspective. So basically what we're trying to do is to support businesses to access international markets, as I've put on the screen. And that's very simple. It's a very simple economic proposition. International trade helps support growth and development. Now, we don't take a political stance on globalization or whether, which bits are good or bad. We're facilitators. We don't have a political stance on this. We're enablers, if you like. And particularly important in that is the barriers that smaller businesses face. Huge conglomerates have the sort of level of overhead that they can deal with some of the issues much more easily than small businesses. So we focus in particular on small businesses, micro, small and medium-sized enterprises, and particularly the sorts of barriers that developing countries face. So we'll come back to that in a little while. And so from that perspective, one of our sort of overall goals is to try and contribute to achieving the SDGs, that the Sustainable Development Goals and the United Nations 2030 Agenda, and obviously these days, post-pandemic recovery. I'm sorry, my slides are being a little bit difficult today. UNCITRAL has a website. You can see at the bottom here, it's uncitral.un.org. Now, in fact, since I created this slide, we're just having a rebranding of our website, so it looks a little bit different, but the buttons are basically the same. And I'm going to give you the individual web references as we go through, because this website is not necessarily the easiest to navigate, but it is an extremely comprehensive record of what UNCITRAL does. And it also explains to you just about every document that we have. We like to talk about UNCITRAL being the home of transparency, and I'll talk a little bit more about that in our working methods, which I'll come to later. But basically, every decision that has ever been taken in UNCITRAL can be found through this website. Every working paper that UNCITRAL's looked at in developing a legal text is on this website. So everything is there, you just got to know where to look. And the other thing I want to draw to your attention, as I'm just showing you here, is that it's a United Nations website, and it's therefore available in the UN's 6 official languages. That's Arabic, Chinese, English, French, Russian, and Spanish. And so if your mother tongue isn't English, and I appreciate many of you may not have the mother tongue that's represented in these, but you may have a more accessible language available through our websites. Everything is available that way. And so I talked about UNCITRAL's texts. So what UNCITRAL actually does is it issues legal instruments, and we'll look at the particular types. But the idea is that we issue documents that states can use to support their commercial legal environment. And these legal texts, they can take the 4 different forms that we'll see, cover these areas. So this is UNCITRAL's take on the life cycle of businesses and what they need for commercial transactions. And you'll see at the top there, there's dispute resolution. Now, dispute resolution is very important because it's a fact of life. And one of the things that disputes arise in commercial transactions, and it's one of the earliest areas, right back in the Middle Ages, where merchants agreed to try and settle their disputes in as amicable way as possible. Clearly, there's the international sale of goods. That's really important. These days, of course, even our phones and things are a mixture of goods and services. So we're looking more at moving into the digitized area. Procurement and PPPs is covered in UNCITRAL because governments enter into contracts to buy and sell, to buy what they need to deliver services as if they were private parties in many ways. And you can see down the other side, we have e-commerce, winding up businesses, security interests, that's securing access to credit, payments, transport, and as I've mentioned, MSMEs, and then there's an online dispute resolution. So if you imagine we're dealing with the businesses from cradle to grave. In the MSME side, we're looking about how to set up a business. We're then looking about transactions, running a business, access to credit, getting your goods and services across the world, and also then eventually exiting the market, which from a macroeconomic perspective is really important because that's what allows new businesses to access credit and establish. So what is it and why do we do this? Why do we issue these texts? If you imagine, go back to our hypothetical Kenyan flower seller, if he's trying to sell to, I think we have a colleague joining us from Germany, if he's trying to join from Germany, to sell into Germany, he doesn't know the German legal system, so it's unfamiliar. He's not really sure how he'll be treated. And many countries, Germany has a good system of trust and governance, some countries have less good ones. And those translate into increased transaction costs. You've got to find out about the system, you've got to work out what's going on, you may need to travel. It has a higher overhead. And this is a real disincentive to selling overseas. So we were established to try and deal with these issues. And the way that we want to deal with this is through issuing legal texts that instead of saying when you sell into Germany, you've got to use the German legal system, even if you're in Kenya. And from the German buyer's perspective, you've got certain things about the Kenyan legal system that you've got to be aware of, and which has exactly the same concerns about transaction costs. We try and issue texts that everybody can use. So we call that harmonization, talk convergence of the rules. So it matters less now whether it's German or Kenyan law. What we're talking about is we'll agree to use a neutral third area. And those are the legal texts that UNCITRAL issues that are neutral and that you can choose to use for your international transactions. But also we hope that governments will use these texts in their national laws, because then the system as a whole is converging. And how we do that we'll come back to. So we were set up to address this. Now, these questions had been tackled in other areas, and one of the things that we wanted to do was to set up a body that was really truly international, that allows developing countries to have a voice, because clearly if it's just a Western or a more developed country system, it won't work. We therefore take a very progressive approach. We identify in our system What are the problems we're trying to agree, we're trying to deal with? And we look at these questions that I've set out on the slide. We look at how different systems are, how complex it is, and try and agree a factual solution. If we're worried about how this will happen, what's the practical solution we can all agree will work? And then we try and agree a common legal standard. So we find a particular arrangement, as you might have seen in the arbitration rules. This is what's going to happen. And some of these are legislative texts, and we call those model laws. And we might have, like the model law on international commercial arbitration, which states can plug into their national system. Where we need more flexibility, we may have legislative guides, we can have guidance, and we can have rules like the arbitration rules. These are common standards, they're flexible, and they're not binding, because that allows states to adapt them to their local circumstances. And so they're not identical. And what this means is this is the beginnings of convergence, because people will agree on certain aspects of this area of law. Eventually, when you see that the harmonized aspect works, states sometimes agree, actually, we're going to commit to using these international standards, and we have a convention. And my colleague Judith is going to talk about the Singapore Convention on Mediation, among others. And what we've had here is we've gone through agreements on model laws on arbitration. We've gone right through to a convention on mediation that allows you to enforce those agreements. And these come into force as a matter of public international law, as many of you may know. So we look at this as a progress over time, and that's how UNCITRAL seeks to harmonize and to converge the rules on international trade. And it does this through three areas, if you like. We're the Secretariat, as Tim's kindly says. Our plenary body, if you like, is UNCITRAL, it's the Commission, and it sets our agenda, and it sets our work program, and it delegates work to working groups that prepare these legal texts. But really important to note here, it's a UN body, so all UN member states can take part. Some are UNCITRAL member states and some are observers, but that really doesn't matter in practice. And they're the decision takers. And then what they also need is support from experts that might either be technical experts or international organizations that would use UNCITRAL's text. So they take part too, also as observers. Everybody talks, we try and find a factual solution, and eventually we come up with a system for a particular legal problem in the areas that I've talked about. And we do this through formal meetings twice a year, once in New York and once in Vienna, which can be a little bit disruptive. So it's quite a slow process, but because everybody takes part, we build consensus on a solution, which then becomes sustainable. The other thing we recognize is that we might issue a legal text, but all that is a book. What we need to do is to make sure that states understand it, that they can use it, and that they're aware of, obviously, what it's supposed to mean, and that judges who might be called to interpret it understand it. So as you can see on this screen, the area that I lead is to work with states and indeed other users through providing technical assistance. So we help draft laws, through explaining how provisions work, through training judges and so on. Clearly, these days, that's all online. And we do have on our website, as you can see, under capacity building, some tools, e-materials and case law that can help. You will see on our website, we have a series of working groups coming up, and this is the schedule, if you like, for the year. And those of you who are interested can see this at the web link. You can't take part in the meetings, but all the documents are on our website. And indeed, as I said earlier on, with the Home of Transparency, there are digital recordings for those of you with severe insomnia who can listen to the entire 5 or 6 days of deliberations online after the event. So thank you very much, Tim. I'm delighted again to have had this opportunity, and I'll hand back to you.
Thank you very much, Carolyn. I'm amazed that you're able to cover everything that UNCITRAL does in such a short but really terrific overview. And for those of you who haven't actually dealt with UNCITRAL in more than just your particular subject matter area, I really recommend that you have a look at some of the materials that Carolyn has put forward, because there is so much good work that's being done. One of the exciting things about LAWASIA is we do have observer status, and so we're very happy to facilitate people becoming involved even more directly for those of you who are out there with particular areas of interest. But thank you again, Carolyn. We're going to change gears now, moving from Vienna, where the Secretariat is based, to the Regional Centre, and I'm delighted now to welcome Athita Komenda, who is the head of the Regional Centre for Asia and the Pacific. There is only one regional centre, and that's in Asia, in Incheon, Republic of Korea, established in 2012. Athita is currently the head there, having come across to UNCITRAL from Thailand, where she worked in a number of very significant roles in the commercial and international commercial area, and has a very broad international background as well, having trained at various universities, including at Harvard Law School. So, Athita, please inform us now about the Regional Centre and the work that you're doing in Asia.
Thank you very much, Tim. Hello to you, Shreyas, LAWASIA friends and participants. Let me try to share my screen.
That's perfect, Athita.
Okay, so it is in full screen mode, is that correct?
Yes, that's great.
Great. So hello again, everyone. Greetings from the UNCITRAL Regional Center for Asia and the Pacific in Incheon, South Korea. It's an honor to join you today to introduce the work of UNCITRAL in the Asia Pacific. Caroline has already provided an excellent comprehensive overview of UNCITRAL's mandate, its legislative work, and developments. My presentation will focus on another dimension, the non-legislative work of UNCITRAL, with a particular focus on the Asia-Pacific region, including how LAWASIA members may collaborate with UNCITRAL RCAP. As Caroline noted, the mandate of UNCITRAL was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. Harmonization, such as that achieved through the adoption and uniform interpretation and application of UNCITRAL texts, facilitates cross-border trade by decreasing transaction costs for users of the system and also consumers. To promote the use and adoption of UNCITRAL texts, in addition to national legislation reviews, the Secretariat undertakes two other main types of activities: the provision of technical assistance and capacity building, along with the collection and dissemination of information on developments in the field of international trade law. The core of RCAP's work, my office lies here, focusing on jurisdictions and stakeholders in the Asia Pacific. Technical assistance and capacity building activities range from organizing briefing missions for government agencies to assisting international development agencies in using UNCITRAL texts in their law reform projects, to co-organizing webinars like this one to raise awareness of and familiarize public and private stakeholders with UNCITRAL texts and their use. By way of background, UNCITRAL RCAP is UNCITRAL's only regional center in Incheon City, Republic of Korea. Our building where our very small office resides appears in the background. RCAP opened its doors in 2012 with the support of the South Korean government to carry out UNCITRAL's mandate to approximately 60 jurisdictions in the Asia Pacific region, working with government officials, the judiciary, legal and business experts, and academia. I myself joined RCAP in early 2019, and some of you here may have met my predecessors, Luca Castellani, who is now in Vienna and Secretary to Working Group 4 E-Commerce, and also João Ribeiro, who is now with the Hague Conference. In addition to myself, the RCAP team consists of secondees from the Korean Ministry of Justice and Hong Kong SAR Department of Justice, along with 2 program assistants and our amazing interns from across the world. To raise awareness of UNCITRAL instruments and developments in the Asia Pacific, RCAP collaborates with regional stakeholders. In particular, RCAP collaborates with the Korean Ministry of Justice, Incheon City, and KCAB International to co-host a series of annual flagship events in Seoul and Incheon, namely the UNCITRAL Special Session for Asia Pacific Developing States, the Incheon Law and Business Forum, and the Asia Pacific ADR Conference. RCAP also co-hosts with the Hong Kong SAR Department of Justice the UNCITRAL Judicial Summit every 2 years, including this coming fall. In the wake of COVID-19, all activities have smoothly transitioned to hybrid or virtual formats. In addition to government stakeholders, RCAP partners with regional institutions on specific focus areas, projects, or flagship activities. For example, RCAP has an ongoing collaboration with the ADB, Asian Development Bank, to promote legislative reforms facilitating trade and investment in the region. The partnership has been very successful. Our cumulative activities have led to 4 new ratifications of the New York Convention in the AP region, Papua New Guinea, Palau, Tonga, Timor-Leste, and approximately 40 AP jurisdictions have adopted the model law on international commercial arbitration, with an increase of about 33% since 2016. The strong regional interest in enforcing contractual obligations via a predictable and neutral dispute settlement regime has also led to the successful launching of the Singapore Convention on Mediation, with over half of the 53 signatories and 4 of the 6 states parties hailing from the Asia Pacific and South Pacific. But my colleague Judith will discuss more on that in her much anticipated upcoming presentation. For participants interested in learning more about UNCITRAL and RCAP, I invite you to join our upcoming virtual and hybrid events throughout the region. UNCITRAL RCAP has also successfully partnered with LAWASIA to raise awareness on a variety of UNCITRAL texts and developments. Most recently, since I joined RCAP, we have co-organized a panel at the LAWASIA 2019 annual conference in Hong Kong SAR to discuss UNCITRAL e-commerce instruments and developments. And you can see Shreyas there on the far left, but Tim, sorry, you're actually off screen in the audience somewhere. We also had a post-COVID webinar last fall on the use of international commercial mediation along One Belt, One Road. So we are delighted to enhance our ongoing partnership with LAWASIA with a series of regional activities this year. For our academic colleagues in the audience, UNCITRAL RCAP invites you to co-host an event under the UNCITRAL Asia Pacific Day flagship series. This is an annual series of academic activities that RCAP co-hosts with institutions of higher learning in the last quarter of every year on a wide range of UNCITRAL thematic issues. The format ranges from in-class lectures to multi-day regional academic conferences, depending on the partnering institution's capacity and preference. In so doing, we aim to raise awareness of the international commercial legal landscape and the role of UNCITRAL to law students and other stakeholders. In 2020, RCAP co-organized a total of 19 UNCITRAL AP Day academic events with 35 partnering institutions in 10 jurisdictions in the region. We look forward to co-hosting more activities this year, particularly in the South Pacific and South Asia, and therefore welcome proposals in this regard. For more details on the AP Day series, we invite you to visit its dedicated webpage. A digital report for the Commission is also forthcoming, which will be published on the same webpage. Another equally important dimension of the RCAP mandate is the collection of information related to the use and interpretation of UNCITRAL texts and international trade law and developments in the region. In particular, the Secretariat has established a system for collecting and disseminating information on court decisions and arbitral awards relating to UNCITRAL conventions and model laws that have emanated from the work of the Commission. The purpose of the system is to promote international awareness of the legal texts and to facilitate uniform interpretation and application of those texts. The system is called CLOUT, or Case Law on UNCITRAL Texts. Just very quickly here, CLOUT is explained in detail on the website shown here in all 6 United Nations languages. The CLOUT digital database is a searchable collection of selected court abstracts or arbitral awards that cover UNCITRAL conventions and model laws by the states and on which there is relevant case law. This includes decisions and awards that interpret or apply a specific provision or provisions, as well as those that do not refer to a specific provision, but relate to the legal text in general. For instance, decisions to the effect that a text is not applicable to the case at hand would be included. The purpose is to facilitate the uniform interpretation of these legal texts by reference to international norms, which are consistent with the international character of the texts as opposed to strictly domestic legal concepts and tradition. Individuals like LAWASIA members can submit clout cases to the Secretariat for publication consideration by one of two ways, either as a national correspondent appointed by the government or as a voluntary contributor. The individual will be credited in the abstract if the Secretariat selects that abstract for publication. We would welcome law members' contributions to the work of UNCITRAL and RCAP via clout abstract submissions for publication consideration, particularly from those jurisdictions where there are not yet many abstracts. Finally, RCAP invites those of you interested in learning more about us to peruse our webpage, to reach out via email, and to subscribe to our mailing list via the QR code on the screen. Thank you again to LAWASIA, Tim, and Shreyas for this opportunity. Can I end with the bonus slide? So this is where we are. That's G Tower and our surroundings, immediate surroundings of Central Park. So we look forward to seeing all of you here post-COVID, and we would welcome initiatives with LAWASIA to co-host in-person activities in Incheon when it is safe to do so once more. Thank you again. Thank you very much.
Athena, that was really wonderful. Thank you. I was very interested to see your slide for the Asia Pacific Day. I don't know whether you can just bring that back up, the map of the Asian region. And the reason I do that is thank you to those of you on the chat who've shared your jurisdiction. I've noted that the jurisdictions where people have said hello include some jurisdictions which are not yet shown on the map for Asia Pacific Day. So Nepal, a bit hard to see, certainly New Zealand, Malaysia, Cambodia. I know we've got people attending there. It would be great if you know, you can take away from this seminar the possibility of engaging with the theatre and the regional centre and a local university to promote the work of UNCITRAL. I've been very fortunate, as Athena was mentioning, to have attended some of the events in the past, which are really awareness-raising sessions. So one in Vietnam I didn't attend, but a colleague did. One in Macau I attended, one in Thailand, and of course the main trade law seminar in Incheon, Korea, are really great opportunities for where individuals can engage. So unlike the working groups, you can engage with the regional centre, and I'm sure Athena would be delighted to hear from you and you know, to bring more jurisdictions into the fold. So again, thank you very much, Athena, and I'm sure there'll be some questions for you a little bit later on in the discussion. We're going to turn now to a specialist topic or specialist topics, and we're delighted to welcome Dr. Judith Nieper, who is based in UNCITRAL headquarters in Austria. Judith has a very distinguished academic and practicing career before joining UNCITRAL. Now, Judith is currently the Secretary of Working Groups 2 and 3. Now, that's a very important role for those of you not familiar with UNCITRAL. That means that Judith is the person who largely has the job with generally the chair of the working group and maybe one or two others in the in an expert panel of preparing for each session and then following the session to try and assimilate all of the material which has been discussed and the developments which occur in the working group sessions, which is no easy task. But what it does do is it gives her a unique perspective on UNCITRAL's current work in the area of dispute resolution. And so with that introduction, I'd like to welcome Judith to present or to make her presentation. So please, Judith, over to you.
Yes, thank you very much, Tim, and thank you very much for promoting me. I'm in the team working with Working Group 2 and 3. I'm not the secretary of these two
Oh, I'm sorry. Okay.
No problem. I'm trying to share my screen. Do you see it?
We do.
Properly?
Yep, perfect. It's great.
Okay, perfect. So you may see that I have a slightly different background than all the others. And this is because I wanted to give you a flair of where the texts I'm going to present are discussed. They're discussed in New York and in Vienna, and this building behind me is the building in Vienna. So somehow I have my bonus slides that Atita had at the end of her presentation. I have it in the background. Dispute resolution has been on the agenda since the establishment of UNCITRAL. So it has always been a very important part of UNCITRAL's work since its establishment. And you have here slides on all the texts that have been developed by UNCITRAL, except the first one, which is the New York Convention. The New York Convention has been developed in 58 already, so predates UNCITRAL's creation, but from the beginning, states emphasized the need to have an enabling arbitration framework environment to make sure that the New York Convention could be successful. So one of the reasons to create UNCITRAL was somehow the New York Convention, and that's why from the very beginning, UNCITRAL focused on arbitration so as to create an environment that would allow for the New York Convention to properly develop. And as you see today, that was certainly a very successful approach. So you have as a second text that after the New York Convention, the arbitration rules. They have been developed in 76, adopted in 76, and as Caroline already said, this is usually the entry point in many contracts. So many, and we get many requests on how to apply these arbitration rules. We also got a question while preparing for the seminar, what the main difference with other rules is. And one of the main differences is certainly that the UNCITRAL arbitration rules are to be used in the ad hoc setting and not institutional rules, like for instance, the ICC rules that are linked to the institution. We further have, when states saw that purely contractual rules would not help to create a truly enabling arbitration environment, we developed a model law in '85, which gives the procedural framework for the arbitration process from the beginning till the end, helping thereby to implement the New York Convention. Then you see here a text recommendation to assist arbitral institutions. This is because the UNCITRAL arbitration rules are ad hoc rules, so the Commission and the states decided that there should be recommendations how you could adapt these arbitration rules to an international setting. And this is what many arbitration institutions took. You can see it on the status page on our website. Further, we have notes on our organizing arbitral proceedings. These are explanatory notes to highlight and to explain to potential users what arbitration means, giving an overview of matters that might arise without promoting any best practices. And lately we have technical notes on online dispute resolutions. This is a text that is, again, a non-binding descriptive instrument that was intended to be used for disputes arising in cross-border low-value sales or service contracts, concluded using electronic communication. This is a topic that, especially after the pandemic experience, will certainly be again on the agenda of UNCITRAL in one way or another. Then we have, and there you see that work is always continuing. We currently are discussing expedited arbitration. So the working group just finalized the expedited arbitration rules, and we do hope that they are adopted at the next commission session, which will take place in June, July of this year. So the idea here is to have a streamlined procedure which should last for 6 months from the beginning of from the date of the constitution of a tribunal. We had one question in that regard. So here you have how many states did adhere to the New York Convention. We have 168 states. So that makes the New York Convention the most successful trade-related instruments, and the model law has been adopted by 85 states in 118 jurisdictions. And in that regard, we had a question whether if you do adopt the model law, that requires centers to adopt the UNCITRAL arbitration rules. No, this is something different, non-related. So adopting the model law does not oblige arbitration centers to act in one way or another. The arbitration rules are really only contractual rules. So with this complete package, and the package is consistently evolving, even regarding the New York Convention, we had the last state joining was Belize in March 21. So you see that still we have a rise in the adoption of these texts, although they are already very, very popular. There has been one question what the advantage of our arbitration texts are, and I would say that the advantage, and this is true for all of our texts, not only in the area of arbitration, is that all of these instruments are very largely discussed, and they thereby represent best practice, and they are tested throughout the world. They are truly universal because we have normally around 90 states discussing all of these instruments. So the advantage is that many stakeholders do participate in our discussion, do contribute their expertise, and that these instruments are fit to be used in very different regions of the world. All of the instruments I was mentioning so far are on arbitration in general, because our texts have been drafted in a very generic manner. So they can be used between private commercial companies, they can be used for investor state, they can be used for state-to-state dispute, or can be used for parties that rely on institutions. So very different settings. However, at a certain point in time, states claimed that there is, especially in the investor states dispute settlement area, that there are certain issues that needed to be treated differently than for all other areas. And that's why we had discussions that resulted in the adoption of the rules on transparency in treaty-based investor state arbitration, and which provides for a transparency regime in these disputes. There has been subsequently, there has been a convention adopted, which is implementing these transparency rules to existing treaties that have been concluded before the entry into force of the rules on transparency. When that work was completed, and here you see the transparency registry, where we are publishing cases that are done following the rules on transparency. When that work was completed, states agreed that there's still a number of issues that are specific in the context of investor state, and that's why we had a working group that was tasked to discuss potential investor state dispute settlement reform. This is a 3-step mandate. So we have a first step was to put everything on the table that might raise issues. The second step was to see whether these issues needed reform. And the third step, and this is where we are now, is to discuss solutions. You find all, and here you have a screenshot, you find all the information related to these discussions on our web page, and you are also informed on what is going to be discussed to be discussed next. So that was arbitration. Big topic of arbitration, and probably you could speak on all of these texts for 1 hour separately, but now I want to break and discuss on the other big topic we are dealing with, and this is mediation, which is an additional tool for businesses and for states to solve their disputes. Here again, the UNCITRAL was for a long time discussing these topics. So we have the UNCITRAL conciliation rules that date back to 1980 already, 1980. So this is a text, the title conciliation rules. You can see here that we changed terminology. In the UNCITRAL context, the term conciliation and mediation are used interchangeably. But it was discussed at one of the last sessions that the term mediation is the term that is more used, and this is why we changed our lead terminology. So the new texts, for instance, the Singapore Convention, will use the term, as the lead term, will use the term mediation. So after the conciliation rules were discussed, we had in 2002 a model law on commercial mediation, a model law on commercial conciliation again. And the idea was to provide a procedural framework on the whole mediation proceedings. There is one article where states could not find an agreement on, and that was Article 14, which dealt with enforcement. So Article 14 of this model law just says every state is responsible for the enforcement. There is no way of finding a harmonized approach to enforcement. It's too different. States are, the national systems are really too different. There's no way of harmonizing this bit. You can see that we managed to enforce enforcement after 20 years. So this is maybe a good example how the discussions are developing. We managed to find an agreement, and we have, like the New York Convention, we have now a convention on international settlement agreements resulting from mediation, also known as the Singapore Convention, because it was opened up for signature in Singapore in August 2019. When the Singapore Convention was adopted, it was decided to also update the model law on international commercial conciliation. And this is the long title you have here, the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation. And what was done was to add a section on enforcement. So it's the model law is still consisting of the old parts of the model law from 2002, with an additional section 3 on enforcement. We have already, and that shows that the Singapore Convention is gaining momentum. We have already 6 states that are party to the Singapore Convention. The Singapore Convention entered into force roughly a year after it had been opened for signature, which is extremely quick. And we have additional 47 signatories. You see them in blue. And we got information from a number of states that they are about to finalize their ratification process. So probably when we meet next time, I need to update my slide, which I will of course do with great pleasure. Work is always continuing in the area of dispute resolution, and we have currently at the Commission session, we will discuss the update of the conciliation rules. First, to change the title to mediation rules, but also to update these rules and to make sure that they reflect the new text, the Singapore Convention and the updated model law. We then drafted, like the notes on organizing arbitral proceedings, we developed some mediation notes that give an overview of the mediation process. And finally, we also drafted a guide to enactment and use of the UNCITRAL model law, so that states can easily get an overview when they are considering adopting the model law, what each of the articles would entail and what the discussions by the working group were. We further have some ideas for future work. So we had some proposals by states. We had, for instance, the proposal from Japan saying we need to take stock. We had further proposals from Israel and Japan to continue working on dispute resolution, especially in the area of high tech. And we have exploratory work done in the area of dispute resolution relating to digital economy, which might raise some specific issues. If you do look at our website, you are able to follow all of these developments, but it might be enough to also ask Atita, who is really our person in the Asia Pacific region, who can give you regular updates on all of these discussions that take currently place. Thank you very much.
And thank you very much, Judith, for that very interesting and comprehensive overview. And I was interested to see 168 states have signed up to the New York Convention, which is effectively 87% of all member nations in the UN. Some of them which haven't signed up yet are in the Asia Pacific, so there's some future work for us to do. Final word from me, just to recognise participants who've identified themselves from Fiji, Norfolk Island, Singapore, Italy and Germany, so welcome to today's seminar. And before I hand over to the Deputy Chair and my co-moderator, Shreyas Jayasthima, I'd like to thank the panelists very much for your presentations. It's been absolutely terrific. So I'll hand over now to Shreyas, who has become a very good friend and colleague through our work together on UNCITRAL. Shreyas is a partner, founding partner of Ayana Law. He's passionate about international dispute resolution and a whole lot of other technology-based things. Also has offices not only in India now, but also in Singapore. But Shreyas will now close out the session dealing with questions and answers and talk to you about how you can get involved too with our committee in LAWASIA. So thank you very much, Shreyas.
Thank you, Tim. And thank you for your excellent leadership and all the efforts in pulling this together. Straight away to the questions. In the interest of time, I think we have time for maybe one question to each speaker. There are a number of pre-submitted questions. We've not been able to cover all of them, but we've tried to synthesize them into some groups. So may I suggest that the first question be directed to Carolyn. Once again, many thanks for the excellent presentation. These are two questions from Nepal and the Philippines. The first pertains to the prospects of the impact of the work of UNCITRAL on international trade. Is that a measurable impact or not? And secondly, the question from the Philippines is the impact of COVID that you've seen on UNCITRAL as an organization, as well as if there are any specific impact on the rules pertaining to arbitration. Carolyn?
Thanks very much, and thank you for these engaging questions, and it's delightful to see that people are really thinking about what we're saying. In terms of future prospects, I think one of the things that really comes out from what Atita said is that we can issue as many texts as we like. We can say, here's a model law on insolvency, here's a model law on particular areas, here's how to have good PPPs, contracts, or whatever. But unless people actually use them, there is no real harmonization of international trade law. There's no convergence of rules. So for us, we need to make sure of two things. The first, that our texts are really relevant. And the second is that we really help people use them so that they work. And if we find things that don't work, we then go back and fix them. And so we try and do the two things. So Judith has mentioned some of the areas that our member states have highlighted as being really important for the future. And generally we're doing, if you like, a COVID pandemic recovery fitness check of our existing instruments. Are they good enough to support economic recovery? Could we do more? And so that's a sort of legislative approach. And we're also looking at specifics that we can help states with. And I'll give you two, and this goes on to the second question, a couple of really simple examples from the public procurement perspective. Now, public procurement is an area where governments can spend money to support small industry in their country. So we try and make sure that they do that in an effective and sustainable way through our work on public procurement. That's a discrete area, and we're looking at that to see how that can be harnessed. But going back to how can we prove that what we do is positive? Well, as Tim kindly said, I have a background originally in economics, and the short answer is it's almost impossible because there's too many variables even if we could build a model. But just occasionally something pops up. And again, from the public procurement area, in Bangladesh, there have been a lot of reports on the digitization of the public procurement system, the tenders and so on. And a few years ago, The Economist reported that that led to, if you look at every dollar that was invested, $668 return. Now, it's only one example, but it's a really good one. And it pulls together two UNCITRAL areas. And the World Bank now is recognizing the recent developments there. So you can see, but it's not so easy to put a number on it. What we do see is there's lots more commercial contracts. And so we're really working hard to put that together. I will just say that I also saw a couple of questions about can individuals participate in UNCITRAL sessions? The short answer is no, but there are facilities, I'm sure Tim will issue some information about this, about how to get your thought process into the UNCITRAL system, and it's a very important thing. And we'll make sure that the website or somewhere from this seminar has a little bit more information about that. Thanks a lot.
Thank you, Caroline. And answering that straight away, LAWASIA itself has observer status in some of the working groups, all the working groups in UNCITRAL. And so we look actively for people to volunteer through this. There are also some national committees that have been set up, which also facilitate the engagement of private individuals in Australia, Japan, and India. But moving quickly to Aditya. Aditya, you spoke about the work of RCAP, and it is, after all, the Asian century, they say. And so we do have a question from your home jurisdiction, from Thailand, asking how specifically can the Asia-Pacific region benefit from undertaking harmonization with the UNCITRAL instruments. And I know that one part of that answer has already been provided by Caroline with that fantastic economic statistic from Bangladesh. It's astounding to hear that, actually. But keen to hear about other impacts. Aditya.
Thank you. Thank you to the participant from Thailand. Khop Khun Mak Ka, and happy Thai New Year's, Suk San Wan Songkran, because we're celebrating that right now. Carefully due to COVID. A very interesting question. Well, Asia Pacific can benefit from the work of UNCITRAL like any other jurisdiction can benefit from the work of UNCITRAL, which is by adopting, using, and uniformly interpreting our texts, and also helping to develop our texts through government representation and also observer representation. Harmonization facilitates trade and investments. A common legal framework would do that. So becoming part of that would help the Asia Pacific region enjoy the benefits of harmonization and also pass the decreased cost to consumers and end users of the system throughout the life cycle, I think, of a business, as Carolyn has so aptly mentioned. So it would help the Asia Pacific region connect more globally and also within the region itself. I think if all these areas of international trade and commercial law are harmonized, we would see a dramatic uptick in trade throughout the region. Just some examples of specific instruments, for example, RCEP now uses one of the UNCITRAL instruments, the ECC, Electronic Communications Convention, as a benchmark. The CISG is really quite popular with the onset of One Belt, One Road through China. China is a main user and main promoter. That would also benefit the region. And of course, with the rise of the Singapore Convention on Mediation, where a large number of the signatories and state parties are there, that would also provide an alternative way for parties to enforce contracts. So that's just in a snapshot. Also to reach out to perhaps government officials who are listening in on this seminar and who want to more actively engage with our work. Government officials are always welcome, not private individuals, not so much, as Caroline had noted, because we're an intergovernmental organization. So yeah, in a nutshell, thank you.
Thank you for that. And we're on time right now, and I've requested if LAWASIA can continue this for just about 5 minutes so that we can conclude. And so, Judith, over to you. The question is, you spoke a little bit about mediation and as an option for international trade and dispute resolution. And very briefly, you did touch upon ODR. So the questions we've had from Singapore and the Philippines is on whether ODR has now been fast forwarded by the pandemic, and whether mediation is also seeing a greater uptick in these current times.
Yes, these are certainly questions that will be further discussed by the Commission, and when we do the stock taking, it will be interesting to see whether further work is requested in this area. What we have done so far, both in the new text on the expedited arbitration rules and in the mediation rules, we have included, the states have included a rule allowing for the use of technological means. So this is something that has not been highlighted in the other texts. Highlighting it now doesn't mean that it's not possible under the UNCITRAL arbitration rules, because you have flexibility there as well. But in these new texts, it has been explicitly spelled out. If we will have further, more detailed work on this area is something that needs to be decided by the Commission.
Thank you. And with that, it's my pleasant duty to thank each and every one of the speakers. Thank you very much, Caroline. Thank you very much, Judith, Atita, and thank you very much indeed, Tim, for putting all of this together. To Magda, to Shana, and Julie from the LAWASIA team. And final remarks to say that LAWASIA in particular is delighted in the UNCITRAL committee. Tim and I are absolutely delighted to have pulled this together, and we're very grateful to UNCITRAL for participating so wholeheartedly. And we hope that we intend to have other events like this which disseminate information, and we invite involvement of all these participants here and anybody who's watching further on YouTube when we're offline to please get in touch. And we would like to facilitate involvement of individuals, if not directly as representatives in the working groups, but at least in terms of debate and dissemination of information around UNCITRAL texts. We also welcome further ideas for future discussion webinars. And with that, I would like to say thank you to one and all, and especially now to the participants for hearing us out. Good evening and good afternoon and good day to you.